David Clendon.
Mr Chair. Mr Chair, I'm pleased to take a call just to speak to some of the detail of this legislation, of this bill, and to highlight the reasons the Greens are not supporting this legislation through the House. It goes right back to the regulatory impact statement. We're basing this legislation on very little evidence, and that point was made in the RIS by the officials, who note that it's not possible to accurately report recidivism data for such a small, unique subset of offenders. There is not a lot of evidence in this legislation to support, or surrounding this legislation to support such a quite draconian measure, because it has to be described in those terms. It is quite a draconian measure to go to this extent. The lack of compliance with BORA, Bill of Rights Act, and indeed international conventions and standards has been noted. It's interesting again to note in the early evidence we had from officials that very similar legislation to this in 4 Australian states that enables the ongoing detention of inmates after the expiry of their sentence has been found by the UN Human Rights Commission to breach the International Covenant on Civil and Political Rights. And given the similarity of that legislation with what's been proposed here, it's most likely New Zealand will find itself on the wrong side of the UNHRC, and I think that's very regrettable. Not least of all, given that this afternoon, in fact, we are passing, or rather progressing, legislation that the Greens do support, that we believe will achieve much of what is intended to be achieved with this legislation. So much has been made of the principles of this bill, and we're constantly hearing this reference to the fact that it is not punitive. The principles 5A say that orders under this Act are not imposed to punish persons. I defy anyone to suggest that this is not a form of punishment. Semantically, yes, you can dance around that to some extent. Looking at the conditions that can be imposed on people subject to these orders, essentially it is detention, perhaps 1 or 2 more creature comforts, with a modicum more of the autonomy, the quality of life that this legislation talks about, but it is an inherently punitive regime. People are prohibited from possessing quite a long list of items without specific permission from a residence manager acting on behalf of the chief executive. Basic things like tobacco and alcohol, and yes, of course, tobacco, nobody supports the use of that, I certainly don't, but it is something that free people, adults, are entitled to make their own decision about. In prisons, of course, alcohol and tobacco are banned, and that would be banned also in these residences, so-called. Electronic communication devices. People cannot own phones, in other words. There's very significant restrictions on access to mail. They may watch television and receive newspapers, but any incoming mail and outgoing mail will be censored by the manager of the residence. These are punitive conditions. These do not reflect quality of life or autonomy. People may not keep live animals, for example. People are denied pets, which is a commonplace sort of a thing that people do in their real lives. So in order for a person to be made liable to one of these orders, in order for the public protection orders to be imposed, it rests heavily on this issue around health assessment, so that a person coming up to the end of their determinate sentence will be assessed. Essentially, there must be at least 1 registered psychologist and 1 other person who must be at least a psychiatrist registered to practice in New Zealand. All well and good, so the court will be presented with 2 reports. Then the court itself, or the person to whom this assessment applies, can also choose to have health assessments done by other assessors, by other psychiatrists, psychologists. There's no guidance in this legislation as to what the courts should do when, as will inevitably happen, there is conflicting advice, conflicting evidence. These are very subjective issues. Psychiatry, and I feel I can say this with no sort of reflection on the profession, it's an inexact science. There is a level of subjectivity. There are clinical tests, surely, But equally, there has been a high level of subjectivity. What is a judge to do? What are the courts to do in a situation where there are 2 for and 2 against, for example? Mr. Chair.
David Clinton.
Thank you, Mr. Chair. So I think that's quite an unsatisfactory, given the consequence of the assessments that can be made, the fact that this could effectively see people kept in detention for indeterminate, for basically forever. The point has been made that there's quite a high bar required in order for these orders, these public protection orders, to be triggered. To an extent, yes, but equally there are the health assessments, psychological assessments and so on. But the decision is made by the court on the balance of probabilities, which is a bar that is set for civil proceedings. A balance of probabilities is not sufficient for a criminal investigation, for a ruling in a criminal court. And yet effectively, as I said, people who have these orders made against them will be kept in conditions not dissimilar to prison. Very similar, in fact, to the situation that a person might be in if they were close to release, for example, the self-care unit type of thing, though arguably a person in a residence would actually have fewer rights and more restrictions than somebody still completing a sentence in a self-care unit of one of our prisons. And I hasten to say I support the notion of units like that within prisons as self-care as a step towards release and reintegration further down. So we note that people subject to these orders will be allowed to work if they can generate an income for themselves within the residence or in some means acceptable to the residence manager. Then that's allowed, that they can earn money and have it managed on their behalf by the residence manager. I think the kicker there is, though, that if a person begins to earn money, then they can also have the ticket clipped, despite the fact that they are in detention and they have completed the sentence to which they were subject for whatever crime they've committed. Nevertheless, if they start earning money, then a certain amount of that can be taken off them to meet the cost of their board and lodgings, presumably, which seems a pretty unhelpful thing. So there's some peculiar language in terms of rehabilitation. We're told that residents are entitled to receive rehabilitative treatment if the treatment has a reasonable prospect of reducing the risk to public safety posed by the resident. So this is not an expectation or something we would seek to insist upon. It is an entitlement, something they may do. The question of whether or not a resident, a person subject to an order, actually is able to get rehabilitation or some sort of program is actually down to the assessment made by the residence manager. These must be quite extraordinary people, these residence managers. They will undertake, when a person moves into a residence, so-called, the residence manager is responsible for a needs assessment to identify special medical requirements, cultural or religious needs of the individual, any skills or capacities of the individual, any educational needs, and finally they can assess any steps to be taken to facilitate rehabilitation and reintegration. That's an extraordinary load to put on one individual, I'd argue. We don't know what sort of level of requirement, what expectation will be, what qualification people might require for these jobs. We do know that while they are acting as a residence manager, they may not perform any function under the Corrections Act, which would exclude a number of people. But it does seem that we're putting a great deal of reliance, in a sense, on these residence managers who may be managing a residence conceivably of one or as few as one and certainly only a handful of people in it. The practical application of this legislation just leaves open many more questions than it answers. It does seem that, as I've said, the ongoing conditions that these people will be subject to, any time they leave and enter the residence, they can be strip searched, and that can be an obligation. They can be forcibly strip searched. They can be put in seclusion, which is rather gentle language. Essentially, they can be put in solitary confinement and kept there until the residence manager deems it appropriate that they should be released. They can be restrained, physically, forcibly restrained. All of these are conditions that inmates in prisons are subject to. I see very little to differentiate between a person allegedly under a civil order, a non-punitive order in a residence, and the conditions that apply in a prison. So, sir, for these and other reasons, we'll be opposing this legislation.
Mr. Speaker, Mr.